Welcome to another video from Lawyer Society. In this video, we'll be talking about the recent issue at Pune and one important provision of law from the Juvenile Justice Act which you must be knowing if you want to understand how the Juvenile Justice Board could have denied bail to the person in Pune. So the facts of the case is that a juvenile aged about 17 years old drunk and drive caused the accident of two individuals who have died, and the JJ board in Pune has granted bail to such person with very lenient conditions, which has caused a lot of uproar on social media. A lot of people are talking about this and news channels are also reporting about this. But what is the one provision of law which you must be knowing if you want to understand JJ Act and how this person could have been denied bail by the JJ board, and how upon appeal such bail could be cancelled even now? If you read section 12 of the Juvenile Justice Act of 2015, it provides for how the bail must be dealt with under the JJ Act. When you read subsection 1 of section 12, it says when any person who is apparently a child and is alleged to have committed a bailable or non-bailable offence is apprehended or detained by the police or appears or brought before a board, such person shall, notwithstanding anything contained in the CRPC 1973 or in any other law for the time being in force, be released on bail with or without surety or placed under the supervision of a probation officer or under the care of any fit person. So when you read subsection 1, you understand that generally bail is mandatory for a juvenile offender. But when you read the proviso, let us read the proviso right now. Provided that such person shall not be so released if there appears reasonable grounds for believing that the release is likely to bring that person into association with any known criminal or expose the said person to moral, physical or psychological danger, or the person's release would defeat the ends of justice. And the board shall record the reasons for denying the bail and circumstances that led to such a decision. So basically, bail can be denied when one of these conditions are satisfied. Either there is reasonable grounds to believe that he will go into association with any known criminal, say like gangsters, into bad company, and they will commit subsequent offences. Second is the possibility of the juvenile being exposed to any moral, physical or psychological danger. So this is to protect the child, and in his best interest, the JJ board may deny bail and ensure that he is in safe custody. Now the third one is when the court or the JJ board it believes that releasing him on bail would defeat the ends of justice. So this is where you should know that this particular JJ board in Pune could have used this particular power to deny bail to this person. So the words defeating the ends of justice obviously has a large scope, and if you want any particular case law where this provision has been interpreted, you can refer to the case of child in conflict with law, son of Suresh Kushwaha versus State of Madhya Pradesh, criminal revision number 3976 of 2022, judgment dated 23rd February 2023. Now in this particular case, in paragraph 12, it has been said that on a bare perusal of the provisions, especially section 12, it is apparent that the bail to juvenile is not must in all cases, as it can be denied by assigning proper reasons. The law does not say that once a person is found juvenile, he should be released on bail notwithstanding the other facts and circumstances of the matter. It is also explicit that the bail can also be denied if the juvenile's release, in the opinion of the court, would defeat the ends of justice. The phrase ends of justice is undoubtedly a meaningful phrase, bringing within its sweep many factors including the nature of the crime and the merits of the matter. So when you read this particular judgment, you can understand that if the person has committed a serious offence and if the facts and circumstances are taken into consideration, the court has the power to deny bail. And even as per the JJ Act, there is a classification of offences into petty offences, serious offences, and those which are heinous offences. But as per JJ Act, heinous offences are those which have a minimum punishment of 7 years. Here, if you consider the offences committed by this particular juvenile in Pune, it might be 304A, it can be 279 of IPC, and in all these cases it is not having a minimum punishment of 7 years. But strictly speaking, for the purpose of justice, to ensure that we meet the ends of justice, the court could have denied bail using this power under the proviso of section 12 subsection 1. I hope you found this information useful. Do share this around so that everybody gets to understand JJ Act as it is and tries to understand this particular matter in the right perspective. And it is always better to have these well-informed conversations instead of just forwarding the regular news articles. You can forward this particular video if you found this useful. Do subscribe to Lawyer Society for more of these interesting legal discussions. Thank you. Until next time.